as you know, John Huber is suing a whole bunch of people over the death of his son. And in a previous video, I made fun of the lawsuit because it was a total clown show. Oh my God. It read like it was written by middle schoolers. At any rate, some of the defendants in that lawsuit have banded together and they have their own legal team. And this is them, Crivello Carlson S.C. They're based out of Wisconsin and they mean business. Unlike the Levy and Levy group who wrote the lawsuit for John Huber, Crivello Carlson S.C. is not a clown show. They have put together a motion to dismiss, and we're going to read it. And we're going to see that John Huber might not want to put down the order for a new Ferrari quite yet. Hello out there. I am trying to get through.
With his powerful brainwaves cradled in the warmth of reasoning, it's time for Johnny Walker Dredd to straighten you out on a thing or two. Emanating all the way from exciting Las Vegas, Oklahoma, it's the Johnny Walker Dredd Show.
Okay, so here is the motion filed by the defendants in the John Huber lawsuit to have that lawsuit thrown out. So Crivello Carlson filed this motion on the behalf of whom? Well, let's see, we have David Beth and these counties, the county of Kenosha, county of Waukesha, county of Racine, county of Sauk, county of Walworth, county of Washington, and I apologize if I'm mispronouncing them because I'm not from Wisconsin. I did my best. So let's go down and let's read this. And as you can see here, I've highlighted defendants David Beth and these counties. So in other words, they're only asking the judge to throw out the lawsuit against them, not against the others. All of the other people that John Huber is suing, which is including about every police station in Wisconsin and probably some from Illinois. I think he's got probably the Boy Scouts in there, maybe the Comanche Nation of America, the Shriners, you name it. If they're an organization, John Huber is suing them. Well, they're not a part of this, so they're going to have to get their own lawyers. Of course, after this takes effect, they'll probably just copy this one. Now, the only one that can't really copy this is Kyle Rittenhouse. He was added to this lawsuit recently, and so he's being sued as well. So let's go ahead and read on down here. I would read this line by line, but it's very long. It's 51 pages. So I have highlighted certain areas that get to the real gist of things, and I thought I would just expand on those. All right, so introduction. Plaintiff brings this lawsuit against the county defendants. And what's important here is the footnote. It says in the footnote, the facts set forth herein are accepted as true solely for purposes of this motion. They are not otherwise admitted in any way by the county defendants. So in other words, we're going to take the plaintiff's word for it for the time being that the facts that they're claiming in their lawsuit are true. And there's an obvious reason for this. They don't want the court at this stage to assess the merits of the lawsuit according to the facts. They want the court to focus on the law. The facts, well, that'll come later if this thing ever goes to trial. Okay, so we'll skip on down here. Just a few notes here. They're talking about, again, what the lawsuit claims happened. And according to the lawsuit, as a result of the ongoing protests, an emergency curfew was put in place requiring crowds to disperse by 8 p.m. That's going to be important later. There was a curfew put in place. And guess what? Anthony Huber violated it. So did Kyle. But so did Anthony. That's going to be important. According to the lawsuit, also on August 25th, a number of white armed private citizens traveled to downtown Kenosha. Some of these armed individuals apparently intended to defend the city of Kenosha from the demonstrators, who they called evil thugs. I only highlighted this just to show the inanity of the original lawsuit. Whether or not the armed individuals call these demonstrators evil thugs is completely irrelevant. Why would you even mention this? There's no point to this. You're suing the counties. They didn't call anybody evil thugs. You're also suing Kyle Rittenhouse. There's no evidence he called anybody evil thugs either. So what's the point of this? Well, again, I kind of get the feeling that they weren't really writing a lawsuit. They were writing an essay from high school. And so they just cannot resist the temptation to throw everything but the kitchen sink into the writing. And we'll skip on down. The armed individuals were avowedly pro-police. Okay, we'll see later. That's going to cause troubles for the plaintiffs as well. All right, let's go ahead and go a little bit further down. As Mr. Rittenhouse ran from the scene of the killing, he stumbled and fell to the ground. At that point, several citizens, including Mr. Huber, approached Mr. Rittenhouse and attempted to disarm him and save the lives of others. Okay, approached Mr. Rittenhouse? That's all he did? Notice there's no mention whatsoever that Anthony Huber tried to kill Kyle Rittenhouse by hitting him with a skateboard. But again, they don't want the courts at this stage to argue about what happened. It's all about whether the arguments made by the plaintiffs hold up legally. All right, let's go on down here. Plaintiff alleges that the law enforcement officers present on the night of August 25th, 2020, intentionally allowed Mr. Rittenhouse to patrol the streets of Kenosha. Plaintiff alleges that the law enforcement defendants invited Mr. Rittenhouse in, deputized him, conspired with him, and ratified his actions. Now notice there's a footnote on deputized. Let's take a look. Because the allegation of deputization is made so frequently in the amended complaint, and I picked on that mercilessly when I read my earlier video, it was stupid. At no point did the police deputize anybody that night, and yet the original lawsuit claims it all the time. It goes on. The county defendants note that the facts as pled in the amended complaint do not establish that the county defendants deputized any individuals. And it goes on to show why they couldn't have. There's requirements involved. There has to be notifications in writing and things like that, and they have to pass eligibility requirements and other kind of things. And so it's ridiculous to claim that Kyle Rittenhouse and his ilk were deputized that night. Words mean things. That was not too smart. Plaintiff asserts that the law enforcement defendants did nothing to stop Rittenhouse's illegal conduct. According to plaintiff, Mr. Rittenhouse and others were subject to a different set of rules and were allowed to move about freely in areas controlled by the law enforcement defendants. Plaintiff further alleges that the law enforcement defendant officers deliberately orchestrated these circumstances. A clear message was sent that perceived protesters were required to disperse, while armed individuals who supported law enforcement could roam free and assist the officers. These events directly led to Anthony Huber's death, and as I pointed out, they can't make that claim. These events indirectly led to his death, and this motion is going to pick on that quite thoroughly. All right, here goes the analysis. Number 1, standard of review under Federal Rule of Civil Procedure 12b-6 and for qualified immunity. Okay, now all they're going to be doing here is establishing to the court that this whole thing about qualified immunity, in other words, even if the facts as presented by the plaintiff are true, the counties can't be sued because they have qualified immunity. Okay? And what they're claiming in this section is that whether or not the county can exercise qualified immunity has to be taken up now. It can't wait. Let's go ahead and read a little bit. It says here, the protections of qualified immunity are meant to provide an affirmative defense in response to a lawsuit as well as immunity from the burdens of litigation itself, such as complying with the duties presented by discovery requests and trial. Okay, so let me break that down. First of all, it's an affirmative defense. Therefore, you're admitting that, okay, everything you say is true, I done wrong, but it's an affirmative defense, therefore it can't be sued. Just like self-defense is an affirmative defense. And it states a couple of purposes here. One, don't want to be sued, and two, it's quite possible for somebody to file a lawsuit against another simply for the discovery. So they want to go in and find out what text messages, they might be looking for trade secrets. In other words, they want disclosure of certain things. And they're saying here that qualified immunity is meant to protect these counties and cities and police officers and everything from that kind of action as well. All right, we'll move on down. And it finishes by saying, for this reason, an analysis of qualified immunity based on the facts as alleged in the complaint is appropriate at this early stage of the proceedings. In other words, before we do any discovery, before we do anything else, we need you, the court, to settle the matter about whether we have qualified immunity or not. Okay, I didn't read that section. It's very dull and it doesn't really help analyze the merits of the original suit. All right. Number 2, counts 2, 3, and 6 fail to state a claim upon which relief may be granted because Anthony Huber was not a member of a protected class. Now, what's a protected class? Race, religion, all that stuff, right? So, Section A, to state a claim for conspiracy under 42 U.S.C., the plaintiff must be a member of a protected class. In count 2, plaintiff alleges that the defendants targeted individuals of color and individuals allied with them, as those individuals protested against racial discrimination. And what's key here is that they're trying to lump individuals, advocates for, let's say, Black Lives Matter, along with Black people. In other words, the race. Anthony Huber was white. Yes, he had pro-BLM feelings, but that didn't make him Black. And therefore, that doesn't bestow on him a protected class status. Okay, let's move on down. To prevail on a claim under 42 U.S.C., a plaintiff must allege and prove that the conspiracy was motivated by some racial animus. It goes on. To the extent that a claim could be based on some other class-based, invidiously discriminatory animus, the class must be something more than a group of individuals who share a desire to engage in a conduct that the defendant disfavors. Okay, so here we have the police going up against these protesters. And these protesters are avowedly anti-police. They're protesting against the police, right? And the police, let's say, do some really bad things to them because they look upon these people as anti-police, or because they see them as sympathetic to African Americans, for example. The police cannot be sued under this section because they would be acting against them simply because they were engaged in conduct that they didn't like, that is, protesting against them. It goes on. Thus, the animus element of a claim under 1985-3 is not met when the actor is only maliciously motivated. The animus must focus on the plaintiff by reason of his membership in that class. What is the class here? Race. Therefore, to be able to be sued under this section, you would have to show that the police violated Anthony Huber's rights because he was Black or because he was white, but it's going to be kind of hard to claim that they violated his rights because he was white. And it's going to be really hard to claim that they violated his rights because he was Black. It goes on. Plaintiff does not allege that Mr. Huber was a member of any protected class. Instead, at most, he alleges that Mr. Huber was allied with a diverse group of citizens who were united by their viewpoint, protesting police violence against black people. Okay? Section 1985, number 3, is not concerned with viewpoint discrimination. It creates a cause of action based on membership in a protected class, race. And no court has ever held that a person becomes a member of a protected class solely by virtue of his advocacy for or on behalf of that protected class. Therefore, plaintiff's claim of conspiracy under 42 U.S.C. 1985-3 fails as a matter of law. Anthony Huber may have been very sympathetic to Black Lives Matter. That doesn't make him black. Essentially, that's what they're saying. B, to state an equal protection claim under 42 U.S.C. 1983 or 42 U.S.C. 1985, number 2, plaintiff must be a member of a protected class. So in this case, they're trying to claim that the police violated Mr. Huber's equal protection of the law in violation of the 14th Amendment by targeting individuals of color and individuals allied with him to protest against racial discrimination, including Huber. Now keep in mind, they keep sticking and individuals allied with him in the sentence, but that's not what the law says. Okay, we'll read on. As an initial matter, the Equal Protection Clause does not entitle a person to adequate or indeed to any police protection. So forget for the moment the whole issue about whether Mr. Huber was a member of a protected class or not. They're settling right out the gate that, you know what, the police don't have to protect you. Your claim that they didn't is going to be hard to argue as actionable because the police don't have to. Well, we'll read on a little bit more here. And Mr. Huber has not alleged that the county defendants withdrew all protection as would be required for an allegation of unequal police protection. Okay, let's go on now. To state an equal protection claim under 1983, a plaintiff must show that the defendant acted with a nefarious discriminatory purpose and discriminated against her based on her membership in a definable class. Anthony Huber is not black. Again, plaintiff's only allegation is that Mr. Huber was allied with a diverse group of protesters who were demonstrating against class-based discrimination. As a matter of law, these allegations fail to state an equal protection claim under the 14th Amendment. Again, being allied with the group doesn't make you a member of the class that that group represents. So put on all the BLM shirts you want. You cannot claim a violation of the Fourth Amendment just simply because you have certain sympathies towards, let's say, African Americans. Further, plaintiff cannot proceed with his 1983 claim using the class of one theory. Okay, so let's go a little bit further down. A class of one equal protection challenge asserts that an individual has been irrationally singled out with regard for any group affiliation for discriminatory treatment. They are trying to make a claim that Anthony Huber was picked on by the police, that he was singled out for discriminatory treatment. The plaintiff, in this case John Huber, isn't even alleging that. And that's what's important. Plaintiff is not asserting that Mr. Huber was an individual who was irrationally singled out without regard for any group affiliation for discriminatory treatment, as I said. Rather, Mr. Huber was a member of a larger group that was allegedly treated in a discriminatory manner because of their group affiliation. His membership in this group is fatal to a class of one claim, because he cannot show that he was treated differently than others similarly situated. Indeed, he alleges that he was treated the same as similarly situated individuals, other protesters. Because Mr. Huber was not a member of a protected class and was not singled out for differential treatment, he cannot proceed on an equal protection claim under 42 U.S.C. So John Huber wanted his cake and he wanted to eat it too. He's trying to make a claim here that, well, they singled out my son for no good reason. individually, but they also discriminated against him because he was a member of a group. Well, which one is it? Plaintiff also cites to 42 U.S.C. 1985 as a basis for his equal protection claim. And let's go on down here ways. Courts have interpreted this portion of the statute as applying to conspiracies to obstruct the course of justice in state courts. Specifically, the language is interpreted to prohibit interference with state officers, state courts, and state elections. But plaintiff has not alleged that any of the county defense's actions had any connection to state court proceedings, or that the acts of the county defendants were intended to interfere with the actions of other state officers. Even if the amended complaint could be read to assert some kind of interference with the due course of justice, a plaintiff must still establish the same racial or class-based invidiously discriminatory animus as is required to state a claim under 42 U.S.C. 1985, and the plaintiff must be a member of a protected class, and Anthony Huber is not. Therefore, because plaintiff has not alleged any obstruction of justice, and because Mr. Huber was not a member of a protected class, count 3 fails as a matter of law. And again, the Levy and Levy group who wrote the lawsuit for John Huber tried to slip in there constantly that Anthony Huber was allied with these Black Lives Matter protesters and therefore should be treated as if he was black, as far as being discriminated against. However, as I said many times, simply being an ally of a certain group doesn't make you a member of a protected class. C. Plaintiff failed to state a claim under 42 U.S.C. for failure to intervene because he failed to state a claim under 42 U.S.C. section 1985 2 or 3. Okay, so the issue here is that the police should never have allowed this to happen to Anthony Huber. They should have intervened at some point to stop it. It states, anyone who, having knowledge that any of the wrongs conspired to be done and mentioned in section 1985 of this title are about to be committed, and having power to prevent or aid in preventing the commission of the same, neglects or refuses so to do, if such wrongful act be committed, shall be liable to the party injured or his legal representatives for all damages caused by such a wrongful act, which such person by reasonable diligence could have prevented. Okay, now you may be wondering, well, wait a minute now, the police couldn't have stopped it. Well, that's a matter of fact, but we're interested in the law, okay? So again, we're accepting the plaintiff's arguments at face value. We're not going to argue about what happened. Liability under this statute is derivative of liability under 42 U.S.C. 1985 2 and 3. In other words, without an underlying violation of subsection 1985 2 or 3, there is no violation of section 1986. As discussed above, both subsections of section 1985 require that the plaintiff be a member of a protected class in order to state a claim upon which relief may be granted. So again, the plaintiff is continuously running into this roadblock. Anthony Huber was white, not black. Now, you could be white and be a member of a protected class, I suppose, if you're discriminated against because you're white. That I don't know. But I suppose that's true. It wouldn't matter. The plaintiffs never argued that Anthony Huber was singled out because he was white. Because plaintiff has not and cannot allege that Mr. Huber was a member of a protected class, his 1985 section claims fail and results in the failure of the derivative claim in count 6. So things are not looking too well. It just turns out that being white and filing a lawsuit in federal court over civil rights violations is kind of difficult. All right, we read on. Plaintiff fails to state a claim of First Amendment retaliation because he has not pled the necessary chain of causation between the alleged retaliatory animus and Mr. Huber's death. Okay, so we're in federal court, and this is a claim that Anthony Huber has had his civil rights violated, right? And how can you get in trouble when it comes to civil rights violation? Well, first of all, picking on somebody because he's a member of a protected class. That will get you in trouble, but that was what we already took care of. And Anthony Huber was not a member of a protected class, okay? Now, another way that you can get in trouble is that if you injure somebody because he was exercising a constitutional right, in this case, the First Amendment. So let me give you an example. You're a police officer and somebody's filming you, okay? That person can do that. Now, let's suppose that you swipe the camera out of his hands and the camera lands on the ground and it breaks. Well, you have retaliated against that person for exercising his First Amendment rights. That's First Amendment retaliation, okay? And in this case here, John Huber is claiming that his son, Anthony Huber, was out exercising his First Amendment rights. The police retaliated against him. The First Amendment right here was the right to free speech, specifically anti-police slogans and messages and such. In other words, the police got really angry over these anti-police messages and decided to retaliate against Anthony Huber. All right, how well is this going to hold up? Well, let's read. Even if the court believes that plaintiff adequately asserted state action taken under the color of law by Mr. Rittenhouse for purposes of the First Amendment by virtue of plaintiff's conspiracy claims, plaintiff has failed to allege a sufficient causal connection between the county defendant's retaliatory animus and Mr. Huber's subsequent injury at the hands of Mr. Rittenhouse. Okay, so what do they mean by this color of law by Mr. Rittenhouse? Let me give you an example. I'm not a lawyer. I'm doing the best I can. This may not be adequate. Anybody who is a lawyer can maybe straighten me out. But let's suppose I'm a police officer and I see somebody filming me. Now, I don't want that. So what I'm going to do is tell some other person standing around, hey, knock the crap out of him. Take that guy's camera. All right? And that person does so. That person is in effect acting under the color of law. He's carrying out an order of mine, and I'm a police officer. But keep in mind, I didn't take the camera. This other person did. So the connection here is that they're claiming that this whole deputizing thing with Kyle Rittenhouse, in other words, the police have effectively bestowed upon Kyle the status of a police officer by, allowing him to roam around and praising him and all those other things, that Mr. Rittenhouse is now acting under the color of law, and he's doing the police officer's bidding. He's effectively retaliating against Anthony Huber, expressing his First Amendment rights on behalf of the police. Now, this sounds shaky on the face of it, but let's read on. Proof of an improper motive is not sufficient to establish a constitutional violation. There must also be evidence of causation. So it doesn't matter how much the police wanted Anthony Huber to die because he was exercising his right to free speech. You have to show that the police caused it to some degree. Okay, let's read on. Because no court has held that a First Amendment retaliation claim may exist where a state actor, the police, induces a private citizen, Kyle Rittenhouse, to act. This court should dismiss the claim under Rule 12b-6. Okay, we read on. Courts have uniformly concluded that the plaintiff in influence-based retaliation cases, influence-based meaning that they somehow compelled Kyle Rittenhouse to take action against Anthony Huber, must allege facts that, if taken as true, would establish a sufficient connection between the defendant's retaliatory animus and the perpetrator's actions causing the injury. So, what is that connection? There doesn't seem to be any. At no point did the police ever compel Kyle to do anything. It states, it is not enough to show that an official acted with a retaliatory motive that the plaintiff was injured. The motive must cause the injury. Specifically, it must be a but-for cause, meaning that the adverse action against the plaintiff would not have been taken absent the retaliatory motive. In other words, you have to show that if it hadn't been for the police, Kyle Rittenhouse would not have killed Anthony Huber. And it can't be just a matter of correlation. There has to be a causal connection. Some sort of allegation is needed to bridge the gap between the defendant's motive, which in this case would be the police's desire to get even with Anthony Huber because he's exercising his right to free speech, and the perpetrator's action, Kyle shooting Anthony Huber. The same is true in the present case, because plaintiff has not alleged that the county defendants took any direct action against Mr. Huber at all. With this requirement in mind, plaintiff has not sufficiently pled that the county defendants' alleged retaliatory animus caused Mr. Rittenhouse to kill Mr. Huber. According to the amended complaint is when they added these counties and Kyle Rittenhouse to the mix. Defendants subjected Mr. Huber and other protesters to retaliatory treatment by 1. Permitting pro-police armed individuals to taunt, threaten, and monitor the protesters without consequence. 2. Permitting the pro-police armed individuals to patrol the streets. 3. By offering the pro-police armed individuals assistance and praise while ordering protesters to disperse. And 4, corralling and funneling protesters toward the pro-police armed individuals to deal with them. So there could be possibly a causal connection if they specifically funneled Anthony Huber into Kyle Rittenhouse's general area so that Kyle could take care of them. In other words, there would be a conspiracy involved here. There would be an agreement. We're going to push Anthony Huber and his ilk into your area so that you can retaliate against them for having the audacity to criticize us. Okay? We're upset by the messages that these people are saying, and we're going to get even with them by shoving them down into your area, Kyle, and we're hoping that you'll take care of them. Okay, but we go on. There is no claim that Mr. Rittenhouse was one of the armed individuals toward whom the law enforcement defendants allegedly funneled protesters. Nor is there any allegation that Mr. Huber was one of the protesters who was being funneled toward the armed individuals. Even if the law enforcement defendants took these actions based on a retaliatory motive, there is no contention that sufficiently connects those acts with Mr. Rittenhouse's decision to kill Mr. Huber. Highlighted here, allowing or even causing Mr. Rittenhouse to patrol the streets because of some retaliatory animus is not the same as causing Mr. Rittenhouse to kill Mr. Huber. And we end it by saying, because plaintiff has not pled sufficient facts to establish the necessary chain of causation to proceed on his First Amendment claim, count 4 should be dismissed. This was very thin to begin with. The idea that Kyle Rittenhouse was acting as an agent of the police because the police treated him good and allowed him to roam around, do what he wanted, not arresting him, that's pretty wild. Section 4. Plaintiff failed to allege facts that could establish that the county defendant's actions proximately caused Mr. Rittenhouse to kill Mr. Huber. So what they're going to pick on here is the bigger question, and that is, it doesn't really matter all this stuff. You have to show that what the defendants did caused Kyle to kill Huber. And if you can't, then all of these claims you're making tend to fall apart. Okay, let's read it. According to the Supreme Court, it is textbook tort law that a plaintiff seeking redress for a defendant's legal wrong typically must prove but-for causation. Everything would have been fine but for what you did. That's what but-for causation means. Plaintiff must demonstrate that but for the defendant's unlawful conduct, its alleged injury would not have occurred. This ancient and simple but-for common law causation test we have held supplies the default or background rule against which Congress is normally presumed to have legislated when creating its own new causes of action. By the way, this but-for causation is going to give Kyle Rittenhouse a lot of trouble in his own civil suits. I mean, really? You would not be criticized but for Whoopi Goldberg? You would not be facing death threats but for LeBron James? Really? Okay. I just don't see it. All right, we move on. The Due Process Clause of the 14th Amendment does not impose an affirmative obligation on the state to protect individuals from harm by private actors. And what they're getting at here is the fact that the state didn't do what it needed to do to protect Anthony Huber. The purpose of Due Process Clause of the 14th Amendment was to protect the people from the state, not to ensure that the state protected them from each other. Because consistent with these principles, our cases have recognized that due process clauses generally confer no affirmative right to governmental aid, even where such aid may be necessary to secure life, liberty, or property interests of which the government itself may not deprive the individual. Okay, so this part here is really important. It says here, if the Due Process Clause does not require the state to provide its citizens with particular protective services, it follows that the state cannot be held liable under the clause for injuries that could have been averted had it chosen to provide them. As a general matter, then, we conclude that a state's failure to protect an individual against private violence simply does not constitute a violation of the Due Process Clause. So, essentially, because the state has no obligation to protect you, then you have no claim against the state if they don't. Now, there is an exception to this rule. It states, the substantive component of the Due Process Clause imposes upon the state a duty to protect individuals against dangers the state itself creates under the state-created danger doctrine. So, the state doesn't have to come and help you unless they're the problem. As an example, they bust into your house on a no-knock warrant and shoot you. They can't deny you emergency services. They caused your problems. They have to do what they can to fix it. But it says, a duty to protect an individual arises when 1, the state, by its affirmative acts, increases a danger faced by an individual. 2, the failure on the part of the state to protect the individual from such danger must be the proximate cause of the injury to the individual. And 3, the state's failure to protect the individual must shock the conscience. Now, the claim here is that the state didn't intervene to protect Anthony Huber. So the question is that, did their actions increase the danger faced by Anthony Huber? No. Was their act the proximate cause of the injury? No. Did their failure to protect shock the conscience? Well, a lot of people got pissed off by what they did, but I don't think shock the conscience is the appropriate term. A, plaintiff does not allege that defendants caused Mr. Huber's death by monopolizing any avenues or relief or constricting Mr. Huber's access to self-help. Okay, let's read this. The Seventh Circuit has explained that the limited exception to Deschaney's rule of non-liability does not apply where the government does not monopolize the avenues of relief. So We're going back again to this case of under what circumstances can you claim a grievance by the state because it didn't take action to help you. We go on down. In the present case, under even the most liberal reading of the amended complaint, plaintiff cannot establish but-for causation between the alleged actions of the county defendants and Mr. Huber's death. Okay, we've talked about that many times. Plaintiff specifically asserts that the curfew was aimed at protesters, of which Mr. Huber was one. The curfew was not a secret. Rather, plaintiff confirms that protesters were ordered by law enforcement over loudspeakers. This is the last warning. You will disperse. This area is closed. You are trespassing. Leave now. Mr. Huber's presence on the streets of Kenosha and his specific interaction with Mr. Rittenhouse were apparently voluntary, and there are no allegations that any law enforcement officer was involved in any way. Rather than complying with the curfew and orders to disperse, Mr. Huber and Mr. Rittenhouse remained on the scene. At the same time, Mr. Rittenhouse was brandishing his gun openly, conspicuously. Mr. Rittenhouse used his gun to shoot Joseph Rosenbaum. Mr. Rittenhouse then ran from the scene with his rifle in his hands, holding it in a ready position. People yelled that Mr. Rittenhouse had just shot someone, and in response, several citizens approached him in an attempt to disarm him. Mr. Huber was one of those citizens. He decided to approach and reach for Mr. Rittenhouse's rifle to disarm him, but was fatally shot. Causation cannot be laid on the shoulders of the police officers in this manner. Several other intervening factors contributed to this tragedy. Mr. Huber could have chosen not to disarm Mr. Rittenhouse. Mr. Huber could have left and was in fact told to do so. Now, this all stems from a case where there was a drunk patron at a bar. The police arrived, and the man's friends told the police, hey, we'll take him home. The police said no. They put him in the back of the squad car, drove him to a gas station, and let him out. The man then subsequently walked across the street and was struck by a car and killed. And the idea is the police culpable here? Well, it turns out that no, because the police gave this man some various options, and the man chose to go into the back of the cruiser. Even though the police would not allow him to go with his friends, they still gave him other options, and he chose the one to get dropped off at the gas station and walk across the street and subsequently get killed. In this case here, Anthony Huber was given other options. In other words, the state, the police, did not monopolize his actions, his choices on what he could do. He had plenty of choices. He just chose the wrong one. Let's read on. There is no allegation that the county defendants monopolized any avenues of relief or constricted Mr. Huber's access to self-help. There is not even an allegation that the county defendants' actions caused Mr. Huber to stay on the scene or caused him to attempt to disarm Mr. Rittenhouse. Rather, the law enforcement defendants provided and in fact ordered a reasonable alternative by establishing and enforcing a curfew. So in other words, the police officers told Anthony Huber to go home, in effect. Anthony Huber, therefore, had that option available to him. Furthermore, he had the option available to him to not chase Kyle and not try to grab his weapon. Can't blame the police for that. So, essentially, Anthony Huber had plenty of choices that night. He made a bad one. And you can't hold the state accountable under such circumstances. Therefore, plaintiff cannot establish proximate causation between the alleged actions of the county defendants and Mr. Huber's death, and he fails to state a claim upon which relief may be granted. Plaintiff does not allege facts establishing that the county defendants created or increased any danger that caused Mr. Huber's injury. The court must disregard the generalized allegations that provide context but that do not specifically relate to Mr. Huber. For example, plaintiff makes general statements about disparate enforcement of the curfew, but the amended complaint does not allege that Mr. Huber was cited for violating the curfew, or that the disparate enforcement was specifically connected with or caused Mr. Huber and Mr. Rittenhouse's encounter. The amended complaint includes general allegations about law enforcement funneling protesters into an area where they were met with violence. But the amended complaint does not allege that Mr. Huber was one of these funneled protesters. Nor does the amended complaint assert that Mr. Rittenhouse was one of the armed individuals awaiting the funneled protesters. Ultimately, plaintiff does not claim that the alleged act of funneling demonstrators toward armed individuals caused Mr. Huber and Mr. Rittenhouse to meet, or, more specifically, that it caused Mr. Rittenhouse to kill Mr. Huber, when that result would not have otherwise occurred. At its core, plaintiff's entire argument is that law enforcement should have disarmed and/or arrested Mr. Rittenhouse earlier in the night, and that had they done so, Mr. Huber would be alive. But a failure to arrest someone does not give rise to a cause of action under 42 U.S.C. The county defendant's failure to arrest Mr. Rittenhouse did not increase the danger to Mr. Huber. Rather, the county, and notice they underlined increase. It didn't help, but it didn't increase it. Rather, the county defendant's failure to arrest Mr. Rittenhouse resulted in a failure to reduce or eliminate the danger already faced by Mr. Huber by virtue of his presence in downtown Kenosha on August 25th. As a matter of law, a failure to reduce or eliminate an existing danger fails to state a claim upon which relief may be granted. So, the police can't increase the danger that you're facing, but they're under no obligation to decrease it. Section C. The foregoing causation analysis is specific to the state-created danger claim asserted in Count 5, but it is the county defendant's position that plaintiff's inability to establish proximate cause based on the facts as alleged is fatal to all of his claims. Regardless of whether plaintiff has adequately pled an express or implied agreement amongst defendants to deprive Mr. Huber of his constitutional rights, plaintiff has failed to allege any underlying constitutional violation upon which relief could be granted. Therefore, plaintiff's claim of conspiracy under Section 1983 necessarily fails, and Count 1 should also be dismissed. Essentially, there's just not a strong enough nexus between whatever they're claiming about the police's behavior and the shooting of Anthony Huber. So, getting tired, I'm going to stop here. I'll do the rest of the lawsuit tomorrow. It looks like we're just a little bit over halfway through. So, how's it looking so far for Huber? Like my videos, subscribe to my channel.